We also have Mr. VanCallis in high-top shoes. Gail Stein sees high-top tennis shoes being worn by the gentleman on the unveil. Crystal Stadler indicated he was wearing the Nike shoes, and that, in fact, those Nike shoes are high tops. The K-Swiss are not high tops. Let's talk about the shoes themselves. Crystal Stadler clearly indicated that he wore those shoes that night. We know from the videos that we have shown that November of 2013, December of 2013, February 2014, April of 2014, and June 18th of 2014, he owned those shoes. But if you look carefully at those videos, those shoes are in really good shape. Crystal Stadler testified very clearly that she got up the night of the murder, 1 or 2 in the morning, and there's Mr. VanCallis cleaning those shoes, something that she's never seen him do before. The next day, those shoes are missing. There's no physical evidence per se, but it's hard to have physical evidence when you throw the shoes out that stomped her to death, when you wash the pants that covered the shoes that you stomped her to death in, that you get rid of the Carhartt shirt that you're wearing because that disappears, and then you wash the regular shirt. As for the helmet, the potential DNA on the helmet, first of all, you had Dr. Petrangelo indicating that that part on the motorcycle helmet is consistent with what looks like a blunt force blow to her forehead. And Crystal indicated she'd never seen that helmet cleaned before. As you can see from the photographs, when they execute the search warrant 6 days later, that helmet had been cleaned. That helmet had been so clean that, in fact, not even Mr. VanCallis's DNA is on the helmet. But all 5 witnesses on the trail saw that specific helmet. And then you also have the statements Mr. VanCallis made to Crystal indicating that I messed up. You have to stand by me, tell them I was wearing the K-Swiss shoes, and then the text to Donnie that says, erase our texts. If you look at the modifications he made to his motorcycle, that alone is enough to convict him. Putting Bondo on the middle part, the swing bar, the fender on the back, and then you have now a black cowling in front. You look carefully at those videos between the cost video and the other, those motorcycles match up. We know from the app itself and the way the app was put together that, in fact, it was somebody on a motorized vehicle that murdered her, went up the trail. He's seen on that trail within minutes of that murder. I think because the standard here, the threshold is low, and it becomes a question of fact that clearly, based on all of that evidence and more that this court has sat through almost 3 weeks of, we have met that threshold, and we would ask the court to deny defendant's motion.
Well, the court has to view the evidence in the light most favorable to the prosecution. In doing so, all of the evidence, indeed, is pretty much circumstantial. But there is a significant amount of circumstantial evidence which would allow this jury to conclude and deduce that this defendant, in fact, was present. The cell phone records are clear. The eyewitness testimony is debatable, but at some point clear. The clothing identification, including the pants and the shoes, is quite clear. The helmet ID is clear. And more importantly, the statements made by the defendant when he got home, in the testimony of the witness. I'm finding that there is sufficient evidence to go forward to this jury to make a determination as to whether or not this defendant should be found guilty of these charged offenses. So your motion is denied.
Your Honor, thank you for accommodating our motion. We appreciate it. Mr. VanCallis, would you stand up?
And now I need to ask you how you'd like to proceed.
Mr. VanCallis, first take your hands out of your pocket. Mr. VanCallis, since I first met you back in November of 2014, I told you that the day would come you would have to make the important decision of whether you're going to testify or not. Is that correct?
That's correct.
And I told you from day one that that decision would be 100% yours. Is that correct?
That's correct.
And I told you that I was...
Stop you for a second. Did you swear to affirm the testimony you're about to give me will be the truth?
I do.
Okay, so go ahead.
Thank you, Your Honor. And I indicated to you that neither the prosecution could make you testify nor keep you from testifying if you chose to do so, correct?
Correct.
Would you tell Her Honor what your decision is at this point in regards to you testifying in this case?
I will not testify.
And this is your choice not to testify?
Yes.
And you understand that this jury will be instructed that they cannot infer anything negative by your decision not to testify. Do you understand that?
I understand.
Is anybody telling you that you can't testify?
No.
So you do realize that you could if you chose to.
Yes.
And this is something that you've discussed with your attorney?
Yes.
And you're satisfied with his services and advice regarding this issue?
Yes.
And it is your decision and your decision alone not to testify?
Yes.
Thank you.
May I just sort of elaborate on that? First of all, Mr. VanCallis, I discussed this matter with you perhaps 8 to 10 times today, giving you an opportunity every moment for if you wanted to change your mind and consult yourself, correct?
Correct.
So my second thing is, at this point, we have made the decision that we're going to rest because you're not going to testify. There's no point to bring any witnesses that would add anything to the case other than what has already come out. Is that correct?
That's correct.
Okay. And Mr. VanCallis, during the year and a half or so that I represented you, is there any motions that you asked me to file that I did not file?
Not to my recollection.
Is there anything that Her Honor has, I think you would admit, accommodated you bent over backwards many times?
Yes, you have.
And is there anything that you want to bring to her attention about my representation of you that you're uncomfortable with or that you're not satisfied with?
Nothing I can think of.
Thank you, Your Honor. I just wanted the record to be clear.
So we are not going to proceed with any other witnesses?
Yes, Your Honor, we're going to rest as soon as the jury comes back.
Okay. Now, with that knowledge, how are we going to proceed?
Come back for closings on Friday if we could. Your Honor, gives both opportunities to assimilate.
We had discussed yesterday doing closings on Friday. We would prefer that this has been a very long trial with a number of witnesses. Even though Mr. VanCallis is not testifying, I've certainly had to spend my time preparing for a cross-examination of his testimony. Therefore, I would wish to have tomorrow to fully prepare the presentation as well as the PowerPoint presentation that we're going to make at closing. We would prefer, because this court has done it in the past on other big cases like the comic book store case, given us that opportunity to effectively
I
prepare.
have no problem with that.
Okay.
I just want to know what to tell this jury. And you also have to prepare for me a large number of jury instructions to be read as well. So that I think tomorrow will give you the opportunity to do that. And we will have all day Friday because Friday, obviously, I have no other cases planned other than a few here and there, but nothing major.
Your Honor, two things. First of all, Mr. Cotello was very diligent and did provide me the jury instructions. I went over them with him. We found no discrepancy which will straighten out. So he has done it. But he has
Giving us tomorrow to do that. Don't we know what I did?
We're going to work on this tomorrow.
We're ready to close tomorrow.
Yeah, we're not done with the instructions yet, Your Honor. We're close, but we're not done yet.
You all want to come back Friday. That's what you're trying to get across?
Yes, because there would be no interruptions in our closing. We would go right from closings into jury instructions, Your Honor. I think would be a more efficient way of doing it.
Would you like to come back at 8:30 or 9 o'clock?
9:30.
9 o'clock.
We'll see you at 9, but we'll bring the jury in and formally do this with everyone resting, and then I'll have them come back on Friday at 9.
Thank you.
Everyone, just please keep it note. I'm supposed to be before Your Honor tomorrow. Is this a probation violation on a different matter?
We'll talk about that later.
If we could have that
I
Friday.
don't want to interject that here.
Okay, thank
So
you.
let's bring the jury in and let's finish. What's his case tomorrow?
It's a PD hearing, just a personal evidence, it's not a litigation.
You can't do that. You can't do that.
He's asking to move it to Friday.
That's all.
Further down.
Right.
Right.
sometimes I think he puts them in like a car and takes them through the McDonald's drive-thru. It takes so long. I don't understand why. The Dunkin' Donuts drive-thru, I don't know.
All rise for the jury.
Okay, Mr. Sheik, with the prosecution having arrested, how is it that you'd like to proceed?
Your Honor, at this point, the defense would also rest. We would like to go right to close testimony.
Okay. So we're done, basically, with all the evidence. We asked you to leave so we could discuss what we're going to do now next. Certainly with the length of this trial, the enormous amount of evidence that the attorneys need to go through, the bottom line is, and the short end of the story is, I'm bringing you back Friday. So they're going to have tomorrow to get their evidence together, to get their closing arguments together, to get for me your jury instructions together. So I pretty much told them a few days ago they could have a full day to do that. So I'm going to see you back, and we're going to move right into, I've just cleared the docket for the morning on Friday. I have nothing. We're going to start at 9 a.m. You will listen and entertain the thoughts of both the prosecution and the defense, and then you will begin your deliberations. Now, as it pertains to deliberations, I don't care how long you stay in any given day, so you have to at least stay till 5 to deliberate, but if you want to stay Friday, you want to stay till 7, 8, 9, that's fine with me. So that's something that you need to think about if you want to stay longer. But at a minimum, you will deliberate until 5, and then if you need to come back, you will come back on Monday and continue your deliberations. But certainly I will stay long, and any day that you want to stay long. Okay? So you have a wonderful day off. You have to go to work, though, even though, because you're not really here in court. And I will see you Friday at 9 a.m. Please, again, do not watch or listen to anything about this case on the news or discuss the case. Come well rested. It'll be a long day for you Friday. Thank you.
All rise for the jury.